Hi students, today's topic is about the Industrial Disputes Act. The objective of this Industrial Dispute Act is to investigation and settlement of disputes for certain purposes within the industry. In case, what is the significance of this particular act is securing and preserving amity of good relation between the employer and workman, and investigation and settlement of disputes whichever is being arised between the employers and employees, or workman and workman other than people outside the industry, or illegal strikes, lockdowns, or workmen's in the matter of layoff and retrenchment, promotion of collective bargaining. Those are all the areas which has been discussed in this particular Industrial Dispute Act. Actually, the first enactment of this Industrial Dispute Act dealing with the settlement of disputes was the Employers and Workmen's Dispute Act, which is in 1860 itself. Then later on, this act has been replaced by Trade Dispute Act in 1929, when Trade Union Act has been came into force. Then later on, after more amendments, like the Act of 1929 contains special provisions regarding strikes in public utility services and general strikes affecting the community as a whole. These are all the main provisions which has been included after the amendment of 1929. Then the main purpose is to uh, provide a conciliation machinery, that is settlement of industrial dispute in a peaceful manner. The Whiteley Commission made in this regard the perspective observation of whatever this industrial dispute act, that attempt to deal with unrest must begin rather than with the creation of an atmosphere unfavorable to disputes than with machinery for their settlement. We are going to come across what are all the definitions which come under this Industrial Dispute Act. What is the main objective of going with this Industrial Dispute Act, and what type of settlement machineries step by step they are going to take when a dispute is being raised within the industry. When we come across with this Industrial Dispute Act, conflict is inherent in any industry relations today. That is maybe the difference of opinions between the employee or employers, or workman to workman, all come under the heading of conflict. Then interest of labor and management usually opposes regarding any industry, whatever we are come acrossing. Then prevailing unrest conditions, work stoppages, which results in strikes, lockouts, slow down process of production, etc., all are emerged as industrial conflicts or industrial disputes. The definitions which that is when the issues of conflicts are submitted to the management for negotiation, they take the form of industrial disputes. That is, a conflict which they feel it as industrial dispute, by the settlement machineries only they are going to solve it. The special causes of industrial conflicts may be treated as causes of industrial disputes also. Maybe the reason is whatever, because of working conditions or layoffs or strikes or whatever may be. But the term con- conflict is being it is being termed by the management as industrial disputes. The main objective of this particular act, Industrial Dispute Act, is to prevent and resolve industrial disputes and secure amenity and good relations between worker and management for common good for both. This is what the main objective. Any dispute is being raised means how to solve it, how to solve in the systematic procedure which is being giving a direction to the management and also the worker by the government. Now, these are all the important definition which we come across in Industrial Disputes Act. That is, first itself they are explaining about what is industrial dispute. Any dispute between the employer and employee, that is from one company employer to the other company employer, if a dispute is being raised, any indifferences of opinions means, then also we can say it as industrial dispute. Employer to workman and workman to workman, connection with the terms of employment or conditions of labor of any person. That is, here the terms of employment, when we are talking about within the industry or within the organization, any dispute is being raised, or a person who is outside raises a dispute to the person within the industry means, then also we can say it as industrial dispute. Then other important definition in this particular act is who can be called as a workman. Generally in labor legislation we can come across with the definition which is common in any of the act. Why? Because first of all they are trying to explain about who is a workman. Here in the same category only, in Industrial Dispute Act also workman has been defined. Any person including an apprentice also can come under the heading of workman, employed in an industry doing whether it is manual, unskilled, skilled, technical, operational, clerical, or supervisory work, whatever it be, he can be called, that is employee. General term which we use is employee. According to Industrial Dispute, the definition workman can be called as an employee who is hired or reward, whether the terms of employment be expressed or implied, and the purpose of the act includes who has been dismissed, discharged, or retrenched in connection with or as a consequence of any dispute, industrial dispute, or who may be dismissed or who may be retrenched as led to the dispute means, then those are all the people can be come under the heading of workman. Because take example of one person is being dismissed because he is not working properly. Maybe the person who is raising a dispute telling that he is doing good, then that particular case also can be treated as a dispute, and the person who come under the heading can be called as a workman. Here, who cannot come under the category of workman is what this does not include a person means. Who is subject to Army Act, who is subject to Air Force Act or Navy Act means that person cannot come under man in the Industrial Dispute Act. Then who is employed in police service as an officer or other employee of a prison, then those persons also not come under the heading of a person as workman. Who is employed mainly in managerial or admin capacity, then those persons also won't come under workman. Then a supervisor drawing wages exceeding a specific amount also cannot be come under the heading of Industrial Disputes Act workman. That is, a workman who is drawing more than that particular amount of salary or wages means, then time by time these rules is been changing according to the fixation of salary to the supervisors. That persons also won't come under the workman. Then other important definition is what can be called as an industry. As we come across in the factory, which can be called as a factory, the same way industry is being defined in this particular act. Any systematic activity carried on by cooperation between employer and his workman, whether workman or employed directly or through any agency or through any contract, for the production, supply, or distribution. That is, throughout the process of this product or service, any person is being employed, then that particular process activities can be categorized as an industry. Here, services with a view to satisfy human wants, wishes, whether or not we can able to categorize as industry, and whether or not any capital has been invested or such activities being carried out for the purpose of making profits also can be called as an industry. Which cannot come under the heading of industry means any agricultural operation except when the agri operation is integrated with another activity means, and that is prominent one, then that can be categorized as agricultural operation, but it is not as industry. Hospitals, dispensaries, educational, scientific research, training institutions, khadi or village industries all cannot come under the Industrial Dispute Act. Any severe function, domestic service, any profession practice an individual if the number of persons employed is less than 10, cooperative societies where employees are less than 10. These are all the categories which cannot come under the heading of industry. Then, what is the procedure of solving industrial disputes in according to Industrial Dispute Act is proper authority is being appointed under Industrial Dispute Act. Based on that only the settlement of disputes will be come across. These are all the machineries for the prevention and settlement of Industrial Disputes Act. From starting with Works Committee, Conciliation Officer, Board of Conciliation, Court of Inquiry, Labour Court, Industrial Tribunals, National Tribunals. These are all the procedures which can be categorized as settlement. In simple way to understand this machinery for the prevention and settlement of industrial dispute, when I want to say, like when you put a case towards one person and it is being going to a high court, then if it is being given judgment and we are not satisfied with the judgment means what we will do, we'll go for Supreme Court. In the same process, first of all, within an industry, any dispute is raised means according to the number of people whoever raising the dispute, it goes with the step-by-step process. First, it will goes with Works Committee, then a conciliation officer will be appointed to solve the dispute. In but few days he has to solve. If it is been exceeding means it will go to the board. If board is unable to solve the this settlement process, then it will go to court of inquiry, and if it is not been solved within that particular period, then it will go to labor court, and based on that extension of not settlement, it will go to the next level of authorities to settle the industrial dispute. This is what the categories to solve a dispute in the industry. First, we will see with the Works Committee. It is a statutory requirement for constituting the Work Committee. As I said, no, first of all, any industry in which 100 or more workmen are employed, then that employed any day in the preceding 12 months is been raising a dispute means, then whom does it consist of means a bi-party, that is that work committee will consist of a bi-party representation of both the employee and employer, representative of workman equal to that of employer. The term of representation shall be 2 years. Here in a work committee, what kind of disputes or what kind of issues they can be handling is matters arising out of the working of the organization like health, safety, welfare. As we said in Factories Act, any of the provisions which is related to workman is not been properly given to the workman means, then if the workman is raising a dispute regarding that industry, then that dispute will first of all come with the committee. That is what this work committee's purpose is. Work committee is being appointed only when the industry establishment is having 100 or more workmen. That consultative body will be there, and based on that, this consultative body will try to solve the dispute. Then a proper appointment of conciliation officer will be there. He is a person who is working as a labor commissioner or deputy commissioner, and this conciliation officer may be a labor officer. Where industry is having less than 20 workmen means, then this conciliation officer will be appointed. First of all, before coming with the work committee, the number of employees is very less means, first it will go to the conciliation officer only. If the number of employees more, then only it will go to the works committee. That is, conciliation of work is to induce both the parties to the dispute to come to fair and amicable settlement regarding the dispute whichever been mentioned. Mediation, negotiation on proposals made by the mediator versus conciliation officer. That is, he within 14 days start of proceedings, he has to settle the dispute. That is, this conciliation officer will investigate on what happened to the industry, how the dispute is being raised, and if that dispute, what are the causes for the dispute, everything is being investigated by this officer, that is a conciliation officer, and he will send a report to the government. If he is not able to settle this dispute within 14 days of proceedings means, then the dispute is referred to Board of Conciliation and then Labour Court or Tribunal or National Tribunal. This is what happens based on the proceedings. But if the number of workers is less than 20 and it is going with a conciliation officer means, if he is unable to solve the dispute within 14 days means, then it will directly go to the Board of Conciliation. That is what the next level of settlement. Here in board, as the name itself it is mentioning, Board of Conciliation will have a chairman, like court environment we will it can be look like. Composition of this board will be chairman and two or four members will be there. Uh, Duties and powers same as conciliation officer will be there, but in conciliation officer settlement machinery, it is only one person who is dealing with all the activities of investigation, but in board more people are there to solve the dispute. Then this Board of Conciliation will submit a report within 2 months. If they are also unable to submit the report within 2 months, or they are also unable to settle the dispute, then it will go to Court of Inquiry. Here, the appropriate government may constitute this court of inquiry connected with the dispute. Here also, it is more than the Board of Conciliation. One or more persons as members, chairman, and the report, and this court of inquiry will take 6 months of time to solve the dispute. That inquiry and revealing the case will be analyzed by these people within 6 months. Then, if it is not being solved, then it will go to the labor court as issues regarding the labor. The appropriate government may appoint a labor court any matter specifying that second schedule of industrial dispute. That composition again, no, like a court environment, one person should be or having judge of high court, that chairman like person will be the judge of high court, or 3 years being a district judge or an district judge, have held any judicial office in India for 7 years means, then this person can be dealing with the case of this industrial dispute. Then second schedule under standing orders, whatever been mentioned in the standing orders, according to those matters only, this labor court will be dealing with the industrial disputes. Application or interpretation of this discharge or dismissal or service, work, workers wrongly dismissed, withdrawal of concession. These are all the things which are all come under the illegality of strikes or lockdowns, or all matters other than third schedule will be come across in labor court. Then, whether in second schedule or third schedule, it will go to the industrial tribunal. I have mentioned here only tribunal. Industrial tribunal or come across with again, no, whatever the court of inquiry or this board, all the places, it will look like court environment in which few people will be there to solve the dispute. In this tribunal also, industrial tribunal also, judge of high court, 3 years being a district judge or a district judge will be appointed, and the tribunal will be dealing with the disputes of wages, including mode of payment, allowances, hours of work, intervals, leave with wages, bonus, profit, gratuity. These are all the cases or disputes which they will come across in the tribunal. National tribunal is when the dispute level is being in the wide range, that is dispute is in nationwide, means the central government may refer the dispute to the national level. Then the importance will be given to the people from central government. The parties to an industrial dispute are required not to resort to work stoppage if dispute is pending before the Board of Conciliation or adjudication authorities. This is what the level, how the dispute is being going through. Generally, before going with an industrial dispute, when people, that is employees, want to negotiate with the management, that process what we call it as collective bargaining. Here, first of all, what the management will do is they will come with a collective bargaining process. That is, collectively, both the parties will come to discuss with the matters of what are all the grievances they are having. Here, grievances is nothing but a dissatisfaction regarding the employee which they want to raise to the management. Here, these are all the preventive measures which management will take before going with the industrial dispute. That is, before it is taking the charge of as a dispute. First of all, management will try to settle it in the form of collective bargaining. In the collective bargaining, what they will do is presentation in collective manner. That is, demands and grievances will be there. Discussions, bargainings, negotiation on mutual grounds will be there. If in that negotiations, in that signing of formal agreements or informal understanding, if it's it, like it resorts to strike or lockdown, then it will extend to the level of dispute. Bargaining with the help of third party is called conciliation or mediation. Other process also there. Mediator will be brought to solve the dispute with amicable manner. If it is not been solved, again no mutual parties will come for voluntary arbitration. That is, when the parties feel that mutual negotiation will not succeed, it may decide to submit dispute to a neutral person who is a third person, group of persons for arbitration. And award, here award is nothing but declaration of whatever the settlement agreement they are coming across is called this award. The meaning will be different what generally we know about award. Here award is nothing but final judgment, only what we can say it as award, given may or may not be binding on the parties regarding voluntary arbitration. Then the words whichever we are come crossing only we are again seeing with these names. Conciliation and mediation, these are all preventive measures which management will try to do with the settlement before it goes with the form of dispute. Conciliation is also deadlock, explains the viewpoint of one party to other, convey the messages and negotiate. All this negotiation process will be done before going with the industrial dispute. Parties may or may not accept the suggestions. Then adjudication, under the condition when dispute is not settled and parties adhere to strikes and lockouts, government may decide to refer the dispute to adjudication and forces the parties to abide by the award of the adjudicator. This adjudicator here the person like a judge who is telling about the dispute to abide with the judgment whatever he is giving. Based on that judgment only they have to abide with the procedure of this dispute. This prohibit the parties from work stoppages also. If adjudicators something he is been awarding, that is awarding in the sense if he is judging means, then automatically they has to stop with this strike or lockout regarding employer side or employee side. And compulsory method in which parties are forced to go by the power of the state. Decision is imposed by the third party. Basis of decision is law and justice. It may be referred to court of arbitration of tribunal or whatever it be. This is what about the settlement process before it is going with the dispute level. Now, this voluntary reference of disputes to arbitration when we come across, before the government refers a dispute to the adjudication process, the employer and workman can voluntarily refer it to an arbitrator written agreement. But generally this won't happen. Why? Because if that agreements is being raised and they come across with the disputes or negotiation process as a conflict means, then only they will go with the this strike or lockout. This generally won't happen, but before adjudication, what people is advising to do with is voluntarily they have to come with an agreement of no need to go with strike or lockouts. Strike is a weapon which is taken by an employee. Lockdown is a weapon which is taken by a employer. If there are an even number of arbitrations or there, empire shall be appointed whose decision shall prevail if the others are equally divided in their opinions. A copy of arbitration agreement shall be sent to the appropriate government and the conciliation officer, and the same shall be published in the Gazette also. As according to the arbitration settlement of award or the agreement only, it will be released in the Gazette as a notice, that is within the month of the settlement process only this agreement will be published. When the government is satisfied that the persons who have signed the arbitration agreement, the dispute will be settled through arbitration. When a dispute has been referred to arbitration and a notification has been issued, the government may prohibit the continuation of a strike or lockout. Arbitrator shall investigate the dispute and submit the award to the appropriate government. This is what about the settlement process. I will again continue the topic in the next video.